Hello friends, welcome to Vajirao and Reddy's YouTube channel. We are here with a new initiative, that is daily analysis, and we are going to cover today's analysis of 11th of August. We are going to cover the most important topics in news which are recurring in nature and are very important. Very important not only from prelims point of view but also from mains point of view. Hence, we focus on a holistic approach. This holistic approach is definitely going to help you answer questions in prelims, help you write answers in mains, and for your overall knowledge based development, this is very important. One thing which is required from your end is consistency, because we will be doing it daily for you. It is you who has to watch it daily. So without wasting any time, let's begin today's analysis. Now, topics which will be covered in today's session will be: first, Rahul Gandhi reinstated as MP in Lok Sabha. Now, we all know that Rahul Gandhi comes from this constituency Wayanad in Kerala. He was disqualified after a judgment of the Surat District Court. The case was with respect to defamation, and the sentence which he was awarded was of 2 years by that court. And due to this length of sentence, that is 2 years, he was disqualified as an MP. But he appealed to higher courts, and finally the Supreme Court has stayed the decision. Supreme Court has stayed the decision simply means that his disqualification is cancelled. He is again qualified as an MP, and he was seen in the Lok Sabha delivering a speech on the no confidence motion. But as aspirants, per se, this particular episode is not important for us, that on what grounds was Rahul Gandhi disqualified and all. Okay, that is important, but we have to look into the larger picture, that is, what are the grounds for disqualification of any member as a member of parliament. There are grounds for disqualification mentioned in the constitution. We have to study about that. There are grounds of disqualification mentioned in the RPA Act, that is Representation of People's Act. So we have to look into these grounds. From here the questions will be posed. And here we will also be looking into that why Rahul Gandhi was disqualified, on which grounds. Then second is appointment of CEC and EC. CEC, Chief Election Commissioner, EC, Election Commissioner. Now, in March 2023, that is this year, the Supreme Court passed a judgment in which the Supreme Court said that the CEC and EC will be appointed by a committee comprising of the Prime Minister, the Leader of Opposition, and the CJI. That was a judgment of Supreme Court in March. And Supreme Court also said that this committee comprising these 3 members will be responsible for appointing CEC and EC until the Parliament frames a law for it. And now Parliament, a law has been tabled in the Parliament with respect to this. So we'll be looking into what are the provisions of the law tabled in the Parliament, how the CEC and EC were getting elected till now, or were getting appointed till now. So we'll look into these. Then the last piece of news is SC intervenes in Manipur. Now Supreme Court has formed a three member panel to look into the rehabilitation and reconstruction of Manipur. Apart from it, it has also laid down one procedure in CBI to investigate the cases regarding sexual violence. So what that procedure is, we'll look into detail. What the member of the panel will do, or what will be the objective of that panel which is formed by the Supreme Court, what will that panel look into, we'll see in detail in this particular news piece. So let's begin with the first piece of news. Now, the SC has stayed his conviction in the criminal defamation case. Now, in a nutshell, what was the defamation case? He was, heard taking names of the Prime Minister in a public meeting and calling him a thief. So that was the defamation case. Someone filed a suit against him, and he's trying to defame the Prime Minister. And the Surat District Court gave a judgment against him, that is against Rahul Gandhi. And while giving the judgment, the sentence which was awarded was of 2 years. and that is why Rahul Gandhi was disqualified as the MP. But now Supreme Court has stayed the decision of that lower court, hence his disqualification as of now is cancelled. But if Supreme Court in future upholds this particular verdict, that the Surat District Court's verdict is upheld, then again he will be disqualified. Because of the stay, it is there. So let us look into the disqualification of members of parliament. That is very important. That is the most important thing which you should know in this particular topic. Now, whenever a sentence of 2 years is given, then they are given a time of 30 days, the MPs. Okay. And in a 30 days, they can appeal to a higher court. But, this does not cancel their disqualification. By merely appealing in the higher court, their disqualification is not cancelled. 2 years, imprisonment was given. A bail was also granted. And 30 days time was also given that if you want to appeal in a higher court, you can. But you stand disqualified as an MP. So this was the main, I would say, status as of now. And Rahul Gandhi was doing this Bharat Jodo Yatra during that time. Now, legal provisions for disqualifications. Now, there are provisions for disqualifications in the Constitution of India. What kind of provisions are there in the Constitution of India? Article 1021 and Article 191.1. Article 1021 disqualifies the MPs and 191 disqualifies the MLAs. What are the grounds? Office of profit if they are holding any, being of unsound mind or insolvent or not having a valid citizenship of India. These are the conditions or these are the grounds mentioned in these two articles. Then the second constitutional provision is mentioned in the 10th schedule of the Constitution. Grounds of defection. Grounds of defection, like if any legislator or lawmaker is elected on behalf of a political party while being a member of a political party, and after getting elected that person gives up the member of that political party, then that is a ground for defection, and hence the membership of that legislator or lawmaker is cancelled. So there is this 10th schedule which was introduced by the 52nd Amendment Act of the Constitution in the Constitution, and on those grounds the MP can be disqualified. So these are the two constitutional provisions. One out of the constitutional provision is the Representation of People's Act 1951. Now, this particular law is responsible for the present disqualification of Rahul Gandhi. What are the provisions in this law which have made him disqualified? We'll look into that as well. But yes, we look into not only that particular provision, we look into all the provisions of disqualification in the RPA Act. The section 8 of the RPA Act, basically 8.1, includes specific offences such as promoting enmity between two groups, bribery and undue influence of a person. Then 8.2 lists offences that deal with hoarding or profiteering, adulteration of food or drugs, and for conviction of at least 6 months for an offence committed under the Dowry Prohibition Act. This is section 8.2. 8.3, if a convicted person who has been sentenced to imprisonment for not less than 2 years, means for 2 years or more, if the person is convicted for any offence X, Y, Z, if the conviction period or the sentence period is 2 years, then the lawmaker stands disqualified. And it was this section 8.3 which made Rahul Gandhi disqualified, because he was sentenced for 2 years imprisonment for defamation. Remember, this 8.3 does not say that for which offence. It only talks about the length of the sentence. Okay. If the length of the sentence is minimum 2 years, then automatically the lawmaker is disqualified for whatever offence. Section 9 deals with disqualification for dismissal for corruption or disloyalty and for entering into government contracts while being a lawmaker. Section 10 deals with disqualification for failure to lodge an account of election expenses. And Section 11 deals with disqualification for corrupt practices. So these are the provisions in the RPA for disqualification. Section 8, 1, 2, 3. Earlier Section 8.4 was also there. We'll discuss what Section 8.4 was. Section 9, 10 and 11. Now, can an appeal against conviction save disqualification? Now you have to understand this very closely, that merely an appeal cannot save disqualification. Like Rahul Gandhi was sentenced for 2 years imprisonment. He was automatically disqualified according to Section 8.3 and he appealed in a higher court. So just merely by appealing his disqualification gets cancelled? No. He appealed, and after his appeal the Supreme Court stayed the decision of the lower court. Hence he was not, or his disqualification was cancelled. You need to understand this. But before, what happened? This is the provision nowadays. Before, if the lawmakers were convicted for 2 or more years under Section 8.3 and they filed an appeal against a higher court or in a higher court, then their disqualification automatically was cancelled by merely appealing. So that was Section 8.4 of the RPA, which stated that disqualification takes effect only after 3 months have lapsed from date of conviction first, and within that period if a person can file an appeal against the sentence before a higher court, then also by merely filing an appeal the disqualification is cancelled. So it provided a pause on disqualification merely by appealing before a higher court. But there was a case in the Supreme Court, Lily Thomas versus Union of India. You need to remember this case. In 2013, in this Lily Thomas versus Union of India, the Supreme Court struck down Section 8.4 of the RPA Act, calling it unconstitutional, and said that merely by appealing in front of a higher court, your disqualification will not be cancelled. If that higher court stays the order of the lower court, then only it will be cancelled, and this is what has happened right now. The Supreme Court has stayed the disqualification, the order of the judgment of the Surat District Court, and that is why it has been cancelled, and he is back in the parliament. Now, this was very important. Another very important topic is appointment of Chief Election Commissioner and Election Commissioner related to the Constitution. Now, these are very important, I would say, positions in the government of India, because we are the world's largest democracy. We proudly call ourselves as the mother of democracy as well. And to make us a democracy is basically the free and fair elections. The free and fair elections which are conducted by none other than Election Commission of India. Election Commission of India, headed by CEC and EC. How were they appointed? They were appointed by the President as per Article 324. But obviously, the President appoints them on the recommendation of the PM and Cabinet. This was the procedure to appoint them. However, in the law it was also written, in the Constitution it was also written that the Parliament can make a law for their appointment. If they want to establish a procedure for the appointment of CEC and EC, a law can be made. But the law was not made. So, President and Prime Minister along with his cabinet were advising the President, and President was appointing. In effect, they had direct influence over CEC and EC. So, the Supreme Court intervened and said that this method should not be there. By saying that this method should not be there, the Supreme Court did not mean that the President will not appoint. The President will appoint according to Article 324. but the president will appoint on the recommendation of a committee comprising of the PM, the leader of opposition and the Chief Justice of India. The Supreme Court also said that this committee will recommend the president and the president will appoint CEC and EC until when a law is made by the parliament. And now in this monsoon session, the parliament, in the parliament, the law has been tabled by the government. What are the provisions of the tabled law? We'll see. But I hope now you've understood the context of this particular topic, that why we are studying it. The government tabled a bill for appointments of Chief Election Commissioner and Election Commissioner. The bill is tabled in order to give effect to the Supreme Court ruling in March 2023 with respect to the appointments. Now, what was the SC judgment in March 2023? The PM, leader of opposition in Lok Sabha and Chief Justice of India, they will be recommending a name to the president, and the president will be appointing CEC and EC. Now, who is the leader of opposition? Leader of opposition is that person whose party is not in power but is the largest, I would say, opposition party having at least 10% of the seats. Now, this 10% of the seats clause is attached with leader of opposition in Lok Sabha. Technically, according to the definition, any political party who is not in power is in opposition. The largest political party having 10% of the seats not in power is the opposition party, and the leader of that party is called as the leader of opposition. But while giving the judgment, the Supreme Court judges clarified this, that if according to the definition the 10% norm is not met by any political party, then also the leader of the single largest political party in opposition will be treated as leader of opposition and will be part of this committee. So he clearly said, the 5-judge bench, Constitution bench it is called as, presided by Justice K.M. Joseph, said where no leader of opposition is available, the committee will include the leader of largest opposition party in Lok Sabha in terms of numerical strength. So we cannot bypass this person, leader of opposition. Okay. Now just look at the scenario. The judiciary intervening in the executive. However, judiciary does not like vice versa. Judiciary does not want the executive to intervene in judiciary, particularly in appointments of the judiciary. Just closely analyze this. You have to keep this in mind, at back of your mind. Now we'll see other things as well. How was the appointment done till now? Now, in view of the Constitution, the power of appointment of CEC and ECs lies with the President of India according to 324(2) of the Constitution. And the President shall also fix the number of ECs. Presently, there are 2 ECs and 1 CEC. Article 324(2) left it open for the Parliament to legislate on the issue, that is the appointment issue. And now the Parliament is making a law after the intervention of Supreme Court. The procedure in the absence of any parliamentary law governing the appointment issue, the ECs are appointed by the government of the day. So there was no law. So, the government was recommending names to the president. President was appointing. Government means the cabinet, the council of ministers recommending to the president, and the president was appointing. There is no concept of collegium and no involvement of the opposition in this case. So, it was happening like this till now. What was the tenure? 6-year period was the tenure, or up to the age of 65 years. Qualification, closely look at this also. There are no prescribed qualifications for their appointment. Although convention dictates that only senior serving or retired civil servants of the rank of cabinet secretary or secretary to the government of India or an equivalent rank will be appointed. These were the conventions, not mentioned anywhere, that who will be qualified to be appointed as CEC or EC. The CEC and EC election commission has been functioning as a multi-member body, 3 election commissioners, chief election commissioner and the 2 other election commissioners. They have equal powers, receive equal salary, allowances and other prerequisites. the difference of opinion among the Chief Election Commissioner and the election commissioners, if there are any, then it is decided by majority vote. It is not like that CEC is, superior than ECs. Okay, CEC is first among equals. That is it. They hold office for a term of 6 years or until they attain an age of 65 years, whichever is earlier, which we already saw. So was there any difference between CEC and EC? There was one difference, that is difference in the removal. Removal of CEC was just like the removal of Chief Justice of India, that is impeachment process happens in the Parliament. Whereas ECs can be removed by CEC if, grounds for disqualifications are met by them. That was the only difference. Rest, everything was same with respect to them. Now, the provisions of the tabled bill, which the government has tabled right now. They said that the selection committee, which will be responsible for selecting or appointing the people, Supreme Court recommended, Prime Minister, Leader of Opposition and CJI. The government has said Prime Minister, Leader of Opposition and any cabinet minister chosen by the PM. So CJI is removed. Now come back to the topic when I was saying that judiciary does not like interference of the executive or legislature in its affairs, particularly appointments. Why would the executive like? So executive is removing judiciary and bringing its own member over here. So it is like this. A search committee headed by cabinet secretary with 2 other members not below the rank of secretary to the government of India to prepare a panel of 5 members. And from this list of 5 members, this particular committee will choose. Now there will be this is called as a search committee comprising of the cabinet secretary, as it said, and 2 other members who are at the rank of secretary level to the government of India. They will search among the people, take out 5 names, recommend those 5 names to this particular selection committee, and this selection committee will select. Then qualification has also been explicitly mentioned. CEC and EC will be selected from amongst those members who are holding or have held the position of secretary to the government of India. Should be persons of integrity and having experience in electoral processes. So this is the tabled bill. Now the government is being criticized over this position by the opposition. The opposition is saying that this selection procedure will definitely give an edge to the government in appointment of the CEC and EC. So this is basically the issue. And next is the last piece of news, that is Supreme Court intervenes in Manipur. The Supreme Court has taken 2 steps with regard to the situation in Manipur. We all know that the situation in Manipur is very grave. The situation is such that, even the Attorney General of India, while, answering questions in the Supreme Court, said that the situation is so delicate that even if a single step taken by the government is misinterpreted by the people over there, that can lead to grave circumstances or grave situations over there. So every person, whether the government or the state government or the courts, they are handling the situation very cautiously. And in today's newspaper, there was a statement that the Prime Minister has assured that Manipur will see the sun of peace. The sun of peace means a day will come where peaceful situations will exist. Just hopeful and praying to God that this day comes soon, very soon. Now, what the Supreme Court has done on its part, it has taken 2 steps. The first step is formation of a panel of 3 ex-judges to look into the relief and rehabilitation in Manipur. The 3 judges, basically ex-Jammu and Kashmir High Court Chief Justice Geeta Mittal, ex-Bombay High Court Judge Justice Shalini P. Joshi, and ex-Delhi High Court Judge Asha Menon. All 3 are retired. Coincidentally, all 3 are women. And they will be looking into the rehabilitation process in Manipur. The second step taken by the Supreme Court is a probe monitor who will monitor overall probe by CBI in sexual offences in Manipur. Now we might all know about that particular video which was being circulated on the internet where two women were being paraded naked. The other day also I was reading about sexual atrocities which many women have faced in the last few months in Manipur. And those are horrific episodes. So to this investigation for these particular sexual offences, this CBI probe monitor will be there. What does a probe monitor means? What the Supreme Court has said, that 5 officers of the rank of SP will be appointed in CBI on deputation to investigate in these cases. Above them will be this probe monitor. This probe monitor will be reporting to the Supreme Court whatever the investigation findings will be there. And who is chosen to be the probe monitor? It is ex-Maharashtra Police Chief Dattaraya Patsalginkar. He is considered as one of the most efficient police personnel in the country. He has served in certain critical situations or critical postings, like he has been in Nagaland also, handling critical situations over there. So he has been appointed by the Supreme Court. Apart from it, there are 42 state SITs, that is special investigation teams, which are under the state police only, which will be responsible for investigating other crimes in Manipur. We are not going into that, but we will be staying with this probe monitor only. Now step 1, Supreme Court has named 3-member committee. What will be the role of the committee? The members we've already seen. This committee will look into relief and remedial measures, rehabilitation, compensation, which have to be given to the people, restoration of homesteads, religious places of worships, and conditions of the relief camps. All this have to be monitored. All the members being female members definitely will or are expected to have more empathy towards the victims, whether it be women, male, children, any. So they have been very, I would say, smart in forming an all-female member committee to ensure these. These female members committee is being empowered with certain powers so that they can implement, or their orders can implement, the relief and rehabilitation measures effectively. The step 2 is Supreme Court directed that there shall be 5 officers of the rank of Deputy SP or SP who will be brought into CBI from various states. So these 5 officers, SP or Deputy SP. SC also directed that it needs one layer between the investigating officers. One layer is in the form of that probe monitor, ex-Maharashtra Police Chief. This layer will be the probe monitor, whose responsibility is to monitor the probe and report the findings to the Supreme Court. He will be in touch with the Supreme Court and report the findings to Supreme Court. Now, is judiciary infringing too much in the activities of executive? Was judiciary empowered to form these kind of committees? Yes, it was empowered. It is empowered. It has that much of space. But while forming this committee, the Supreme Court Chief Justice of India clarified that this should not be perceived as our infringement upon the executive. We are doing this whatever possible is in our hands to restore the situation in Manipur. After all, we are an arm of the government, and the job of the government is to maintain peace, law and order, harmony in all parts of the country. Whatever the government is doing, we are doing this parallelly. It should not be considered as infringing upon the government. So you should be viewing or analyzing the topics and asking such questions while reading the topics in newspapers. Because if you ask such questions from yourself, you will be closer to answering questions in the examination. And for this purpose, you need to be a thinking mind. And be cautious, you don't have to be an overthinking mind, just a thinking mind. So that is all from today's class. we will be coming up with more exciting and more, useful news that will be helpful in holistic preparation for the prelims examination as well as the mains examination. So stay tuned. Let's meet tomorrow. Jai Hind.